Good morning. My clock on the computer says it's 9 o'clock, so welcome to another session of oral argument with the 5th District Court of Appeal. I know we are sitting as by the Chief Justice's order on behalf of the 2nd DCA in this case. It is our case number 212029. I am Judge Lambert. I will be presiding over oral argument today. With me on the panel, as you see on the Zoom screen here, are Judges Edwards and Harris, also sitting as designated associate judges of the 2nd DCA, but we're on the 5th DCA otherwise. We have one case this morning. As I indicated, it's our case number is 212029. Harmon Parker, PA, FKA Davis and Harmon, PA v. Santec Management LLC, AAO, the Gerber Law Group, PA. Each side will have 20 minutes for their oral argument. You see the clock up in the left corner, at least on my screen in the left corner. The marshal will be taking care of the clock, and he has reserved 5 minutes for the appellant for rebuttal. If the appellant would like some other time, please let us know, and the marshal will adjust the clock accordingly. When you get into your rebuttal time, you'll see the yellow button there, yellow light start blinking. I'll let you know. You can continue on or you can stop. We are on YouTube, so people can be watching us if they so choose to do so. So keep that in mind when you're making your oral arguments and making your comments to the court. Also, if you happen to have some type of electronic device, cell phone, etc., please either put that in the mute or turn it off so the device does not go off to disturb either yourself or opposing counsel or the court during the oral argument. Okay, I guess that's enough of me prattling on. So at this point, counsel for the appellant, I guess that is Mr. Martinez. If you are ready, sir, go ahead.
I am ready, Your Honor, and I would like to reserve 5 minutes for rebuttal, please.
Very well.
So this case is a relatively old case filed in October of 2010. It was a dispute between law firms over a fee. It went to jury trial in 2000, I should have known, 17 or 18. It was appealed to the 2nd District, and this court sat in on that one. Originally, the jury found in favor of the Harmon law firm. The court post-verdict entered judgment, took away the verdict and entered judgment for Santec. And then it was appealed to this court. It was then reversed with instructions to enter judgment in favor of Harmon. The plaintiff, who was originally Gerber Law Firm and who we contend is still appropriately a party in this case. Importantly, at least for purposes of this case, and I recognize this has some broader implications, but importantly, that the judgment was that Gerber take nothing. And because of that, of course, but for the issue that we're here about today, it is our contention that we would be moving forward with a motion to enforce these proposals for settlement against Gerber Law Firm and seek to recover fees for what has been a marathon of a case. Not the longest, but certainly a long one.
Mr. Martinez, just out of curiosity, that original judgment that went up to the 5th, Gerber was not a named party in that judgment, were they?
In terms of the style of the case, not a named party. However, we did bring this up tangentially in our motion for fees with the appellate court. We did move for fees for determination of entitlement as to both Gerber and as to Santec. And that was granted by the court.
We demanded directions to enter an amended judgment. We didn't say add Gerber, right? That wasn't an issue before us at the time?
It was not an issue before you at the time, correct?
Should it have been?
No, because at that point, the only order that had been entered was the order of August 24th, 2018, where the court indicated in the substitution that it was per the stipulation of the parties. That to us placed conditions on that substitution that our contention is this was not a substitution for all purposes, simply as to amend the style of the case. And because per stipulation of the parties conditioned that substitution, we did not believe this was an issue at all. In fact, we didn't believe it was an issue until there was an objection to entry of that final judgment in favor of Harmon. going,
The current final judgment, not the one before.
yes, sir. Yes,
Okay.
sir. And in that, so the current final judgment entered June 4th of 2021. What we've got is is become dynamic in our view. The actual substitution, we do believe it was for a limited purpose. The stated purpose at the trial, and I know I'm not saying anything new to this panel, but we're immediately, from a legal standpoint, immediately before impaneling a jury, we're going through motions in limine. There's a motion in limine by Gerber Law Group, who's still a party at that point and is represented by the same firm, right? Both Santec and Gerber are represented by the same counsel. And they wanted to preclude evidence of this assignment. The court properly, in our view, found that it was relevant because of the bias it could show the jury as far as some of the witnesses. Once the court ruled that it was relevant, Mr. Cathy, on behalf of Gerber and or Santec, as he was there in dual capacity, indicated, Your Honor, based on that ruling, we would move then to change the case style to communicate the assignment to the jury accurately. That was the stated purpose.
So somewhat ironically, if the motion had been granted, it would have been Gerber all along back then?
I'm sorry.
If the motion in limine had been granted, saying don't want to talk about the assignment, then the issue about, well, who should be the party in the caption would never have come up. It seems to be the follow through on all this.
That seems to be a reasonable inference. Yes.
Okay.
I agree. In any event, so what we're being told is, hey, we want to communicate this to the jury accurately. They recognize it had some prejudicial effect. We really didn't have an issue with it, provided that it didn't impact our ability to enforce these very proposals against Gerber Law Group, because that is the entity that brought us to where we were here at that point in time, some 8 years into litigation. We had served 3 proposals for settlement. One of them was substantial. Actually, all 3 of them substantial, but one was for $1,500, one was for $300,000, one was for $50,000. Gerber Law Group chose not to accept it. And so we find ourselves on the eve of trial. They want to change the style name to communicate to the jury accurately. Fine. I don't have an issue with that. We're very much substance over form, provided that it doesn't impact the ability that we're here about today. And the colloquy went on a little bit, and the court said, or Mr. Cathy said, after I responded, as long as we can still enforce against Gerber Law Group, Mr. Cathy, still in a dual capacity, indicates, I'm relatively confident there's law saying that the change of a case style doesn't affect anybody's rights or remedies. We wouldn't be waiving it by asking the case style be changed, but the request was to change the case style simply for clarification of the jury. That's what we are relying on at this point. My response was, if it does not impact our ability to enforce the proposal against the Gerber law firm, I've got no issue. So twice now, I have stated what the problem is. The court appropriately said that would require assent in front of the court reporter by your opponent. Responding to me, Mr. Cathy responded, we agree. And then added, nobody's waiving anything by agreeing, to a change of the case style. The court went ahead and ordered the substitution. We have that order that I alluded to earlier, August 24th, 2018, where the substitution was per the stipulation of the parties. It is our contention that that stipulation was very clearly and specifically exempted, carved out substitution for all purposes, because it retained the right to enforce against Gerber. Where we find ourselves now is in a situation where, if you look at the most recent judgment that's been entered, rather than per stipulation of the parties, or rather than a carve out, it reads as if it's a substitution for all purposes. And we believe the court was mistaken in that regard. Prior to this being entered, we sent a letter to the court. We sent a memorandum of law outlining this issue. This order followed. Our opponents are now arguing that, in fact, it was a substitution for all purposes, and we believe that that is a mistaken analysis. In any event, we find ourselves here today looking down the barrel of a gun. That's not a good analogy. I'll strike that. We find ourselves here today looking at a situation where potentially a condition precedent to enforcement of a proposal for settlement has been taken away. And our argument is that if you take away a condition precedent, you have effectively taken away a substantive right. This involves much broader issues, of course, and that is whether and to what extent a party immediately prior to trial can assign a case, and through a legal mechanism by substitution where the other party objects and wasn't at the table, by substitution can stop the enforcement of a proposal for settlement or undermine the entire public policy behind it. It's a mechanism that, if permitted, would be used probably to an extent where proposals for settlement would become difficult to enforce in the situation of corporations. You open an LLC, you assign it to the LLC, you substitute, and then you say you can't enforce if we lose, so we get a free bite at the apple, which of course is contrary to.
So your concern basically is if we affirm today or affirm this case and you say, okay, fine, I'm going to go forward and try to enforce my proposals for settlement because everybody said at the 2018 trial, we have the right to do so. Your opponent down here is going to say, well, wait a minute, Judge, you got to deny their motion because there's no judgment against Gerber Law Group, PA, and therefore they can't enforce it. Just look at the plain language of the statute. And we all know that everybody swears allegiance to the plain language of the statute.
That is correct. That's our concern. But more importantly, if that is the case right now, we have to, in my view, we have to appeal this right now. It would be difficult. It's far more appetizing to argue against prematurity than to argue against waiver. And I'm quite confident that if we held off on this and we went forward with that hearing, there would be an argument of waiver that this should have been brought up when that judgment was entered, because on the plain face of the judgment, it appears that the court mistakenly is treating this as a substitution for all purposes. And so that's why we find ourselves here today. But there, of course, is a much broader public policy issue in play here, which is when a party reserves, as we have done, and relies on that reservation in entering into a stipulation for substitution, and the court enters a substitution on that basis, what happens? And in our view, what should happen is that the party who rejected the proposal, where the carve-out was placed, should continue to be placed on the judgment for purposes of enforcement of the proposal. And in what form that takes, I don't know. I would leave that up to of course, the collective wisdom of this bench. But I don't believe that it would serve a public policy for settlement to permit this kind of instrument to be used in the manner in which it is being used in this case. And for those reasons, we've requested the relief in the briefs. We do think that guidance would be extremely helpful if there's simply a PCA. Our concern is that we're going to find ourselves here again in the event the court says, no, I did mean a substitution for all purposes. That's what I wrote. That's what the plain face of the judgment appears to indicate. Some guidance, I think, would be appropriate, not only for us, but for other cases. Something along the lines that except in cases of death, right? So in cases of death, substitution is practically mandatory, but that's a statutory creature of a personal representative. But except in cases of death, an obligation under a proposal for settlement, we believe, is non-delegable. An assignment or substitution should not apply to undermine any obligations under a PFS. And we get into a distinction between obligations and benefits, right? So an assignment, obviously in this case, all right, title, and interest, it assigned benefits. But whether you can assign an obligation, which is truly a right that belongs to Harmon under enforcement, that obligation should not be permitted to be interfered with unless Harmon is at the table, the Harmon Parker firm. And if they're not at the table, then it should not be permitted as a matter of public policy to impact that obligation. The bottom line is when it's assigned, they get the benefit of the bargain. The parties can work out between themselves how they're going to handle the proposal for settlement issue, but the parties who are, working on the assignment, but the party who's left out, which is a party that has the right to enforcement, should not be impacted unless they're at the table. It's a matter of consideration.
You're looking from us at a minimum to reverse and direct the trial court or amend the final judgment to include Gerber in it. But you're also saying, could you all write about something that talks about these issues about the scenario we have here and why this should not be permitted?
I think it would be helpful. Certainly for the bar, at least in my opinion. part of that relief, kind of going down a list of if we had a wish list, an indication that a substitution that carves out proposal for settlement enforcement is permissible. Obviously, that's just a matter of stipulation. That a party rejecting a proposal should be included in a final judgment for purposes of determining the judgment obtained and enforcement of the proposal for settlement. And a party, as you've indicated, Judge Lambert, that a party should be included on that final judgment under this scenario, right? In any event, that's the relief we are requesting. We believe that it was properly preserved. We do believe that it is ripe for determination now, given where we find ourselves with the judgment of June 4th, 2021. And unless there are any questions, I will reserve the remainder of my time.
Okay, thank you, counsel. All right, Mr. Steinberg, go ahead, sir.
Thank you, Your Honor. May it please the court.
Yes, sir.
My name is Brent Steinberg. I'm here on behalf of the Appalese Santec Management LLC. Your Honor, the actual issue on appeal is simple, which is that did the trial court err in refusing to join a non-party in the Gerber Law Group to the final judgment? And the answer to that question is no. The trial court, in fact, would have committed reversible fundamental error had it joined a non-party to the judgment. Now, Harmon acknowledges that there's no authority to allow a non-party to be joined to a final judgment, but it essentially argues that we stipulated to it, that we stipulated that Gerber should be joined to any final judgment. And that's just not accurate. You can look at what was said during the hearing. It's pages 185, 186 of the record is the pertinent passage.
Well, let me ask you, assuming we agree with you, how is it that Harmon goes forward and attempts to enforce their proposal for settlement against Gerber?
Well, pursuant to the stipulation, Your Honor, we said in our answer brief that Harmon's not waived any argument regarding the enforceability of the proposals for settlement that were served on Gerber. I guess I should probably clarify what I mean by that, because opposing counsel must have a different understanding than we do. But it's our position, just to clarify, we don't believe that there should be any fee order entered against Gerber at all. But that said, we agreed that the substitution standing alone would not eliminate Harmon's ability to obtain fees against Gerber. We also agreed that the omission of Gerber from the principal final judgment does not eliminate Harmon's ability to obtain fees against Gerber.
Okay, but so you go for, I'm thinking of another case that I have where everybody proceeded down the road under what they thought they were trying the case. And at the end of the day, the trial judge says, oh, wait a minute, you guys have missed all this. I'm entering a judgment in one way because you guys haven't raised this. Or my point being here is, so you're down the road, you have new lawyers in front of a new judge who says, well, wait a minute, I read the statute, look what the statute says, and I can't do this. I'm precluded. The legislature wouldn't like me doing this. The statute says what it says. And so the Harmon side says, my goodness, I told you exactly what was going to happen at the oral argument of June 27 of 2022. Now we lose again. And now we come in front of the second DCA and it gets transferred to the fifth DCA. And you got a brand new panel of, how should I politely, strict constructionists, I'll say it that way. And they say, well, the statute says what the statute says. Tough luck, Harmon. See you around. And Harmon's left holding the bag. That may seem far-fetched to you based upon, if I'm understanding the tenor of what you're saying is, we've had this deal. That is certainly not far-fetched to me to see that coming down the road in front of a different panel would have that consequence.
Well, Your Honor, I understand your concerns, and I think that they certainly would be valid concerns, but for the stipulation. In any other case, a final judgment against a party would be necessary to trigger someone's substantive right to fees. But here, I think the stipulation supersedes that.
Just tying the case I was talking about. The other case is the party stipulated paternity in the case. They went to the trial to discuss time sharing, and the judge says, oh no, the statute precludes me from entering a judgment of paternity, so no paternity. Good luck. And I'm not saying what, in that case per se, but I'm saying the scenario can arise. And I think that's what your opponent is saying. You and the two of you may have discussed this with the judge and had an understanding, but down the road, you know, let's assume under the proposal for settlement, they're entitled to attorney fees against Gerber. It seems like there's no mechanism to allow that. You have to hope that a judge down the road saying, well, I know the judgment, there's just no judgment, but I'm going to enforce it under the statute anyways. And then an appellate court, you know, says, well, you're right. Even though the language doesn't allow that in the statute, under these unique facts, we're going to go ahead and permit the attorney fee award.
Well, there would still have to be a mechanism to get it in front of the appellate court. And if I'm not the one or my client's not the one appealing it, you know, the
other guy, he would be the one that says, I thought I had a stipulation and now I get no fees because the new judge says, well, there's no judgment against Gerber. And that isn't how we were rolling along for the last several years. And now I'm out and now I go in front of the 50C and you've got strict constructionists who say, you know, that's too bad. You don't have a judgment. Judgment's got to be entered. No judgment. And I guess the follow-up is why do you all care about a judgment being entered against you? It's not like it says that you are owing any money. It simply says you take nothing from this case.
Well, you know, Your Honor, the way this came up, there wasn't really a hearing determining whether Gerber should be joined to the principal final judgment. So there's nothing in the record about any harm that would come to Gerber because of it. But if I were to speculate, I would suggest that, you know, perhaps the Gerber law firm just doesn't want a judgment entered against it.
But it's not a judgment entered against. It's just a judgment that says you didn't win.
Well, they assigned the claim in 2015, and for all intents and purposes, haven't participated in this lawsuit since then.
Well, they proceeded for 3 years without worrying about substitution. And I suspect, as I was talking to Mr. Martinez, I suspect if the motion limiting was granted that had been filed by Gerber and the assignment was not brought in front of the jury, then nobody would have cared. You would have gone forward Gerber versus Harmon or vice versa and let the chips fall where they may. Right?
Sure, Your Honor. Yes, the Rule 1.260 allowed the lawsuit to proceed in the name of the assignor, even though, for all intents and purposes, the law firm was not a party to the lawsuit any longer. You know, this was no secret. This was communicated to opposing counsel by no later than 2016, as the record shows.
Well, what if Harmon had a counterclaim against Gerber? You couldn't have then just assign the lawsuit to Santec and say, well, you know, and then Santec would say, well, we're not a party to the counter. Why are we being sued? I mean, isn't that somewhat analogous? They're saying we have a claim against you, you know, whether it has merit or not. We have a claim against Gerber, and now by you simply assigning it to Santec, that in effect nullifies our ability to enforce our claim. If the judge down the road says our claim's no good, well, so be it, then that's fine. But you know, how is that not somewhat analogous to the scenario here? And if so, it would seem like you wouldn't be able to just walk away by assigning it to some other third party.
Well, Your Honor, I mean, I'm bringing us right back to the stipulation that we're agreeing that the omission of Gerber from this judgment does not eliminate Harmon's ability to obtain fees against Gerber.
Mr. Steinberg, basically,
if we affirm and Mr. Martinez brings his fee motion, that Gerber is not going to argue below that, hey, you can't get fees against me because I'm not named in the judgment. It's correct. Argument.
We're going to argue that Harmon is not entitled to fees against Gerber at all. However, we will not argue that the omission of Gerber from the final judgment is the basis for denying Harmon's right to fees against Gerber. I think
Judge Lambert said,
stipulation is binding on that. I'm sorry.
How does it mean to add Gerber to the judgment then?
Well, again, there's nothing in the record about that, but I don't know to what extent having an adverse judgment, even if it says shall go, you know, forward and take nothing and hence without day or whatever the language is. I don't know how that would impact, you know, legal malpractice premiums or otherwise the law firm's reputation. But there's nothing in the record about that. But
Mr. Steinberg, I have a question for you.
sure.
You're essentially arguing that by the stipulation, Harmon waived having Gerber on the final judgment, but your stipulation says nobody's waiving anything.
Well, the stipulation.
How did they waive the right to have Gerber on there?
The stipulation just goes to the fee judgment, not the principal final judgment. All of this discussion was about fees, and there's no fee judgment which has been entered yet. The trial.
But you're saying by entering into the stipulation, Harmon waived having Gerber on the final judgment, any final judgment.
I'm saying that Harmon waived having Gerber on the principal final judgment. I'm not saying that.
But sir, your stipulation, which is what the order is based on, as Mr. Martinez so eloquently pointed out, that says nobody's waiving anything. You can't get any broader than that. I don't see how Harmon could have put anything more into the stipulation to protect their rights, especially in light of the response that nobody's waiving anything. I mean, how much broader can you get than that?
And we agree that they still haven't waived any argument regarding the enforceability of the proposals against the Gerber law firm. Mr. Harmon raises interesting policy questions about, what happens after an assignment occurs. What happens if an assignment occurs after a proposal for settlement has been served and then that's later triggered? And it's interesting questions, and it's best I can tell an issue of first impression, but it just isn't a question that the court needs to resolve today, because under our stipulation.
Mr. Steinberg, I agree with that in absence of them agreeing to an assignment or a substitution of parties, that is a different issue. But when you have the terms laid out so clearly here of the stipulation, I don't understand how you can argue that they've waived including Gerber law firm on any final judgment.
Well, perhaps it's not an issue of waivers, is it just as much as at this point, Gerber is a non-party, and it would be fundamental error to include a non-party in a principal final judgment. Now, the fee judgment's a separate issue, but if we're just looking at whether or not the trial court committed reversible error in entering the principal final judgment the way that it did, the court should determine that it didn't, because there was a substitution. We look at the actual order of August 24th, 2018, and it's called in the style substituting party plaintiff, and then it goes on, and then it says per stipulation of the parties in open court before a court reporter, 1, Santec Management LLC as assignee of the Gerber Law Group PA is substituted as party plaintiff for Gerber Law Group PA. And then it goes on to change the case style. And when Mr. Martinez was reciting what the plaintiff's counsel said, he omitted the words or a substitution of the parties. It wasn't just about changing the case style. It was a substitution of the parties. Nobody's waiving anything by agreeing to change of the case style or a substitution of the parties. So, in our view, the order couldn't be clearer, and it's consistent with the hearing transcript, which makes clear that this wasn't just a motion to change the case style. Certainly that's how the discussion started, but it ended up being a motion also to substitute Santec for Gerber with no caveat or limitation on the substitution. It just says that Santec is substituted as the party plaintiff. And
if this hypothetical panel of strict constructionists that Judge Lambert hypothesized about, if they came about and said, well, you can't get a fee judgment, Harmon, because there's no judgment against Gerber, would you be joining Harmon as an appellant then because you were party to the stipulation?
I believe I don't know that I'd be joining as an appellant, but I think I'd be judicially estopped from arguing that Harmon is incorrect. I mean, the stipulation remains binding on not only us and the court. And I don't believe it was the trial court's intent to predetermine these fee issues. And I know Mr. Martinez said that their motion to join Gerber was filed before the principal final judgment was entered. I'm not sure one way or the other whether that's accurate, because it happened on the same day. It certainly wasn't rendered. It was, I think, on a Friday when the order was signed. And then the subsequent Monday was when it was recorded and hence rendered. So, in that sense, the motion was filed before the final judgment. But the trial court, our whole point here is that this is just premature because the trial court hasn't had the opportunity to decide any of these issues. The trial court hasn't had the opportunity to determine whether any of the proposals are valid, against whom they should be enforced, or in what amounts. And
What if the trial judge says, okay, we've got the motion for fees. Guess what? There's no judgment against Gerber. So here's my ruling. You're denied because you haven't met the threshold under 768.79, and have a nice day. There's my ruling. He doesn't get to the substance of whether it's an enforceable under the verbiage of and the facts of the case. He just looks at the plain language of the statute, looks at the judgment that was entered by the prior judge, and says, A plus B means you lose, Harmon, because you haven't established the predicate. So I don't know how you can say it's premature. We're being asked to give an advisory opinion. I mean, it seems like this has to be resolved before Mr. Martinez can go forward on his attorney fee motions.
well,
No?
yeah, I mean, there's black letter law saying that the trial court has to enter a final order on fees before this court gets to review the fee issue. And maybe we have a chicken and egg problem here where you're saying that the trial court effectively determined fees already.
Well, I don't know that he's
Certainly not.
effectively determined it. He's basically, it hasn't been presented to him, but Mr. Martinez says, well, if I go forward and there's no judgment against Gerber, then I run the very real risk of the trial just saying, it doesn't matter what Mr. Steinberg says, I'm looking at the plain language of the statute, and there's no basis, there's no statutory basis that the legislature has given to me to award fees, whether it's meritorious or not, because you have a condition proceeding that hasn't been met. And so it seems like this matter needs to be resolved first.
Well, I understand
I
your
know you
honor.
disagree with that, but I guess you can see where at least one side of the panel is going on that issue.
I understand your honor's concerns. I don't think that is likely to occur, certainly.
Well, it's easy for you to say that because you got nothing, if it doesn't happen that way, you say, well, that's what we agreed to anyways. If it does happen adversely to Mr. Martinez, consistent with Mr. Martinez's prediction, and you say, well, I did the best I can. What do you, sorry about that, Harmon and Martinez, you got a tough judge there in circuit court land.
I mean, in our view, the stipulation was to any possible fee judgment, and all of Harmon's arguments go to the fee judgment, which has not yet been entered, which is why that we asked this court to dismiss for lack of a justiciable issue. And certainly all of these issues can be brought up before the trial court, and I presume will be. That said, we're 12 years into this lawsuit. I'm certainly optimistic that at some point the parties will be able to finally resolve their dispute, and I won't have to ever appear before you in this case again. But if that doesn't happen, the appropriate time for this court to address the fee issue would be after there's a final order determining fees, not only entitlement, but also the amount. And then the court would take on all of the fee issues, including the enforceability against Gerber and any other issues that either party would take on appeal. It's just, in our view, it hasn't happened yet. And the stipulation, Harmon's not prejudiced at all. They still have all of their arguments. The stipulation provides for that. I understand, Judge Lambert, I understand your concerns about how the mechanism for triggering a proposal for settlement would work in any other circumstance. And I agree with you about that. It's just that we have the stipulation that supersedes how it would normally work in any other circumstance.
Does the intent of the parties in that stipulation play any role in this if it's sort of contradicted by the language in the judge's order? In other words, there was never an intent to replace the parties as a real party in interest, right? This was just to avoid confusing the jury. So it's really not in the case style. The intent was never to say, okay, you're in and you're out.
Your Honor, I disagree with that. If you look at page 186 and the whole discussion, it certainly started as a motion to change the case style to avoid confusing the jury about the issues to be tried. But the intent was certainly to substitute. So right after Mr. Cathy says, this is plaintiff's counsel, nobody's waiving anything by agreeing to a change of the case style or a substitution of the parties, the court says, so I will do an order substituting parties and changing the case style. And then it goes on to discuss how the case style should be altered. So that, and then the order itself, entered the same day, says explicitly that it is an order which is substituting Santec as assignee, as the party plaintiff. So I disagree with your honor that it wasn't just about changing the case style. It was a full-on substitution. The only reason that substitution hadn't occurred years earlier was because of our perceived prejudice that our client suffered by interjecting this issue of the assignment anyway, as what made jury instruction number 2 necessary, where it had to explain what the assignment was, and that makes clear that Santec was the only plaintiff. It says, although Gerber has assigned its claims in this case to plaintiff, Santec Management LLC, you are to only consider the claims of the Gerber Law Group. Plaintiff stands in the shoes of the Gerber Law Group and is entitled to any relief the Gerber Law Group would have been entitled to had the Gerber Law Group not assigned its claims. So the bottom line is that in our view, the trial court didn't commit reversible error by omitting a non-party from the final judgment. Gerber Law Group was substituted as the party plaintiff. Santec is now the only party plaintiff. They were the only party plaintiff in the first final judgment, the only party plaintiff that was in the initial appeal, and are still the only party plaintiff. And for that reason, there's no reversible error has been committed, and certainly an order affirming would not prejudice Harmon on remand in any future fee dispute. They can still seek fees against Gerber. And I see my time's up unless the court has any additional questions for me. We would just ask that you either dismiss for lack of a justiciable issue or affirm.
Okay, thank you, counsel.
Thank you.
Mr. Martinez, you have 6:37 on rebuttal if you want to use it.
All right. I don't believe I'll need it all. The argument that this was a substitution for all purposes, I think, is belied by the record, which is relatively clear. By definition, a substitution for all purposes would not contain a carve out. And because of that carve out, we find ourselves in the position, we still need to rely on these statutes. It's the only legal vehicle that I'm aware of to enforce the proposal for settlement. And as I stated early on, this final judgment, let me get the date just for the record. The final judgment of June 4th, 2021, effectively eliminates a condition precedent to enforcement of the proposal, which is the whole reason for the objection that was brought up contemporaneously. And the simplicity and the broad nature of the stipulation is evident simply by the fact that this takes up about 15 lines in the transcript. I don't think it gets simpler. I do believe that Harmon has preserved his right to proceed in this manner, and I don't believe that the substitution, based on the record before you, could be reasonably said to have been a substitution for all purposes. And for those reasons, we believe the court made a mistake. The trial court made a mistake in the manner in which final judgment was entered. And for those reasons, we would ask that the court author an opinion giving us some guidance on this, or as Judge Lambert, as you indicated, we might just find ourselves here again on the same issue. Thank you.
All right. Thank you, counsel. All right. Well argued. We will stand adjourned, taken under advisement. Judge Harris, you want to call us?
Sir.
Okay. All right. Have a good day, gentlemen.
Thank you.